reports indicating that spectators who had lived through the Khmer Rouge regime had difficulty not attacking the charged person Doik sitting there in that very same seat. One has only to read the daily police blotter to confirm that Cambodia is not immune to violence, as is no society, and for motives much less significant than the crimes of the charged persons. We submit that these facts do support the finding that he justified. That the co-investigative judges did indeed consider bail, but concluded that it would be inadequate in negating their previous findings. As we've stated, the concept of bail is very new to the Cambodian judicial system, and there is no demonstrated capacity and precedent to reasonably conclude that the justice system could handle the first implementation of a bail order for an individual such as this charged person. The issues canvassed by us clearly demonstrate that bail conditions and guarantees offered by the charged person cannot satisfactorily reassure this court that once released, he would not flee, interfere with judicial process, cause unrest, or indeed be safe. I come now to the right of a fair hearing. It is the second issue raised by the appeal, and specifically whether the right to have a counsel present to assist was rightfully waived by the charged person. We submit that this chamber should conclude that the procedures were fair because they offered the charged person all the procedural rights guaranteed to him, and these were properly within his rights to refuse to exercise them. At stake is the right to counsel and the validity of a waiver of such a right. As I said, the defense uses words such as defenseless, objective confusion, and bowing to implicit pressure to describe how the adversarial hearing negatively affected the charged person's ability to make a valid waiver. The argument is that the waiver was uninformed, involuntary, and equivocal. Indeed, this morning, you heard defense paint such a picture once again. Now, we agree with the defense that to be valid, such a waiver must indeed be informed. Specifically, the charged person must be made aware that he possesses the right to have counsel present and that he understands the consequences of such a refusal. We disagree, however, with defense that a charged person should not be allowed to make such a decision once these rights have been explained. Now let's look at the reality as reflected by the record. On the 19th of September, the charged person was given his rights and offered legal representation no less than 3 times that day, and each time rejected that offer. The first opportunity was between 10:45 and 14:40 that day when the charged person met in private with the deputy head of the defense support section, an experienced international criminal lawyer. The charged person was given legal advice and offered a stand-in counsel. The charged person declined this offer, which, as you can see from the case file, was recorded in writing by the defense support unit. Now, this morning, for the first time, almost 5 months after the events, we hear of the existence of notes of that meeting that allegedly contained perhaps relevant information to the case at hand. We are told that these notes were made by the same person who signed that letter and who met with the accused, the charged person rather, Mr. Rogers. And on the one hand, we are told of the contents of those notes, but then told that we cannot really have access to them because they are covered by the client-lawyer privilege, and that such an access has yet to be determined. However, we are also told at the same time that the Defense Support Unit cannot provide legal advice. Therefore, I wonder how lawyer-client privilege can attach to these notes, if indeed Mr. Rogers at the time was not providing legal advice. I also question the efficiency and propriety, if indeed it is the position of the Defense Support Unit, that it can provide evidence to support any arguments in this court, and yet be shielded from having that evidence examined by what is indeed a fundamental principle, that of the lawyer-client privilege. A privilege, I also note, can only be waived expressly by the recipient himself, the charged person, which I have not heard done today. No, something. Now, what?
Cannot hear what you say.
I can speak louder, but I don't think that's going to help. Can the translation hear me? Telephone?
Okay.
Now, I unfortunately, not having access to those notes, I'm sorry, but I'm having a heart attack, but something is shaking here. Sorry. Okay. Not having access to those notes, not having the benefit, for example, of an affidavit by Mr. Rogers, which would have been helpful. All we have to attest of this meeting is this letter that Mr. Rogers himself signed. Now, one would assume, and I think correctly so, that an experienced lawyer such as Mr. Rogers would have consigned to writing all relevant matters, and I submit that he did so. And the only thing that he mentions relating to this encounter is that, and I quote, because I think it's very important, Mr. Nuon Chea declined the offer of a stand-in lawyer to represent him temporarily pending Mr. Son's arrival. Unquote. Nothing about the charged person complaining about his health. Nothing about the charged person wanting a postponement. Nothing else. Now, of course, I have no reason to doubt my learned friend's assertion that the notes he consulted do state what he says they do state. However, not having the privilege of those notes, nor any other evidence as to what they mean, they are not in evidence before you today. My colleague, my learned friend, went on this morning, quite rightfully, about how we must be cautious between allegations and proven facts. I submit to you that you must be even more cautious to confuse what any of us says here as evidence. So we submit that pending the filing of such note and any other evidence relevant thereof, you cannot, in law, consider them as proven facts, and could only do so after all the parties had a chance to address their content. Going back to the reality of that day, the second opportunity given to the charged person was at the initial hearing around 1440, when the charged person was informed of his right to counsel, his right to remain silent, and his right to refuse to answer questions, and his right to wait for his lawyer so he can make such a statement with his lawyer present. The charged person answered, and I quote, "I would like to make a statement despite the absence of my lawyer." The third opportunity was after being told of the purpose of the adversarial hearing at two separate times, and at the hearing around 1625, the co-prosecutors who were not present at the initial hearing, and out of an abundance of caution, as should be properly exercised, requested that the charged person be given another explanation on the purpose of the hearing and his rights to have a lawyer present. The purpose of the hearing was reasserted again by the co-investigative judges, and they also stated that these explanations, including his right to counsel, had been given to the charged person at the initial hearing. The charged person immediately confirmed the co-investigative judge's comments by saying, and I quote, "Yes, that is right. I want a lawyer, but I do not require the presence of my lawyer at this time. I may defend myself at this time. Beginning tomorrow, I will have my lawyer defend me." And then this charged person proceeded for the next 10 minutes or so to give a forceful, coherent, and detailed rebuttal of each of the grounds to believe that he committed the crimes charged, but also of each and every one of the grounds to detain him preventively. I commend you on your scheduling of a viewing of the audio video of the hearing, because at it you will see, as we all saw that day, a former political leader used to speeches righteous in his belief that he had done nothing wrong, articulate and coherent in his arguments, and eager to make his stance without the assistance of anyone, and not the frail, confused, scared old man that has been alleged. There is not a single instance on the record of the charged person saying, "I don't understand," "I am confused," or "I don't know what this is about. Could you please explain?" Not a single one. Yet, the defense wants you to conclude, only based on the fact that the charged person is old and has physical ailments, that he should have been denied his right to make an informed decision. However, there is not a single objective criteria that will allow you to consider the defense arguments as based on the facts. The procedural guarantees of our internal rules, which were offered and declined by the charged person, as I said, are not meant to protect the charged person from making a wrong substantive decision, one that their counsel might not like. Those procedural safeguards are there to ensure that the defendant's rights are upheld which they were in this case. The co-investigative judge's obligation under the rules are equally clear. They are to ensure that the charged person is informed of his rights, understand them, and that any waiver is clear. They are not obligated to ensure that the charged person understand all the complexities and intricacies of ECC proceedings, nor can they substitute their judgment for that of the charged person. There is nothing in the record or on the events of that day that could have led the co-investigative judges to conclude that the charged person did not understand his rights or that his clearly expressed decision was anything but informed and unequivocal. However, despite that, the defense, to support its arguments, invites you to consider jurisprudence that we submit, however, provides no or limited guidance to this chamber. In our response, we have detailed our observations regarding this decision and the minimal weight they should be given. Further, considering the hour of the day, I will leave you to our response and our comments on decisions such as that of Evans, Cullen, Melani, which we submit, however, provide little assistance in this case. I would point out further that the jurisprudence cited today, without support or copies provided, that of Milosevic, I think can easily be distinguished. Should we be today at trial, where evidence has to be weighed, properly assessed, and tested by the parties, and where the ultimate decision is the guilt or acquittal and possible sentences, lengthy sentencing of an accused, I would indeed urge this chamber to follow the guidance of Milosevic and make sure that the accused is indeed capable of representing himself to a trial. Those circumstances, however, are wholly different from that of an initial hearing where pretrial detention is to be evaluated. As we said, there was nothing on the record or on that day that could have motivated the co-investigative judges to believe that that waiver was anything but informed and unequivocal. We also submit that the waiver was voluntary. And again, I invite you to consult the record to have an accurate depiction of the events of that day. The charged person was examined by a doctor in Palin when he was arrested. I believe even that that doctor followed him to Phnom Penh, although I'm not sure that the case file does reflect that. But what it does show is that the charged person was re-examined later before the commencement of the hearing. At no time was there any indication that the charged person, considering his age, was anything but fit to appear at the hearing. Equally important, at no time did the charged person himself show any signs of physical distress or complain of any such problem. At no time during that day. We would also invite this chamber, to consider the corroboration offered by the results of the subsequent medical examination undergone by the charged person. As noted in our response, the medical experts were unanimous in finding that the charged person was in reasonable health in light of his age and past medical history. The defense assertion that the charged person was unable to think clearly at the hearing, and as depicted today, as argued today rather, is clearly unsubstantiated, as you will again note from a viewing of the audiovisual of that day. In terms of jurisprudential guidance, we would invite you to consult our response, and in particular, the case of Delalich, circumstances which were much more onerous on the accused, despite which the trial chamber concluded that the waiver had been informed and not coerced. Compare that with the decision in Barbera, cited by the defense, which I think can easily be distinguished on the facts and is of little assistance. I would also submit that this waiver was unequivocal. And that is essential indeed, and we agree with the defense. But the charged person declared on numerous occasions, including the hearing itself, that he did not need his lawyer present, in clear language. Further, he stated at the initial appearance that he wanted the detention hearing to proceed immediately after the initial appearance without the appearance of his lawyer. At this time, I do not need a lawyer. I am unsure as to how this could be described as anything but unequivocal. And when later asked to confirm this statement, the charged person declared, I do not require the presence of my lawyer at this time. When offered the possibility of postponing the hearing, when the co-prosecutors sought admission of additional documents, the charged person replied, I can respond without having read the documents. We therefore submit that the waiver was unequivocal and express, and thus left no room for interpretation. Contrary to what has been argued by the defense, the charged person was determined on that day to proceed to the hearing without the presence of his lawyer, something which was evidently reflected by his own statements. We submit that there were no grounds for the co-investigative judges to believe any differently, and we respectfully submit that you should conclude similarly. The defense states further that the charged person was not clearly told of his right to remain silent at the adversarial hearing. While it is true that the charged person was not told again of his right to remain silent at the adversarial hearing, the charged person was told unambiguously of this right at the initial hearings only 4 hours earlier. At the adversarial hearing, it was confirmed that the charged person was made aware of his rights. In both instances, the charged person clearly confirmed that these rights, including the right to remain silent, had been read out to him and that he understood them. This course of conduct was procedurally correct in accordance with the internal rules of this court, as was previously argued before this chamber and considered in the Doig case. Hence, we submit the defense arguments is unsupported by the facts and the law and should be dismissed. As to the rights to prepare a defense, the defense argues that the charged person was not given, and I quote, even a cursory legal and factual briefing, unquote, needed to establish a defense at the adversarial hearing. Again, this argument is not supported by facts. It was precisely on this ground that the co-investigative judges showed a willingness to halt the proceedings. They were clearly told by the charged person not to do so, as he wanted the proceedings to go forward in any way. It is evident that the charged person was offered this right, yet properly refused it. We also submit that the specific purpose of the detention hearing should not be confused with the final determination of responsibility at trial. Thus, the right to adequate time to prepare should be construed in the limited context of the purpose of the detention hearing. Before concluding, the co-prosecutors as well note the very well-argued brief submitted by the Cambodian Human Rights Action Committee. As you have seen, that brief is essentially in support of the defense. And having taken that cue, has been cited extensively by the defense today. However, I would submit that a lot of these assertions, and I submit the ultimate conclusion of that brief and its author, would indeed have been quite different had they have access to the case file and the evidence and the facts of that day. Indeed, I can't but wonder how the SHRAC would have concluded any otherwise, given those facts. But again, as co-prosecutors, we welcome the submission of amicus, and in this particular case of the SHRAC. To conclude, nothing in the record, nor any of the factual or legal arguments articulated by the defense in their appeal or today should convince this chamber that the rights of the charged person were breached at any stage of the proceedings. Further, and perhaps essentially, there are reasons to believe that the charged person committed the crimes as charged and that his provisional detention is necessary. Also, we respectfully submit. Thank you.
The hearing today cannot be finished, so we will continue tomorrow. So we will resume at 9 o'clock in the morning tomorrow. The security, please take the charged person back to the detention facility. I announce the adjournment of the hearing today. Thank you. And the security officer, please take the summon to the charged person.